In association with IQAC of our Bharati Women's College, had an opportunity this national webinar on intellectual property rights and overview. This program is mainly focused to cater the needs of research scholars and the faculty fraternity who are thirst on expanding research. Let's start the session with the invocation.
கருவாக்கி உருவாக்கி என்னையாண்டு காத்தருளும் நன்றி. எங்கும் நிறைந்தோனே எல்லையிலாதானே, எங்கேயும் எப்போதும் என் குலம் காப்பவனே. நெஞ்சம் துணிய துணையாய் வருவாய், எர்மறை உணர்வுகள் பெருகிடச் செய்வாய். உடலில் உறுதியை பெரிதாய் தருவாய், உனை உணரும் அறிவை என்னுள்ளருள்வாய். சுற்றமனைத்தும் காப்பவனே, செய்தொழிலில் ஏற்றம் தருபவனே, எடுத்த செயலில் வெற்றி கொடு, என் ஆற்றல் பெருகிட அருளை கொடு. கருவாக்கி உருவாக்கி என்னையாண்டு காத்தருளும் இறைவா நன்றி. வல்லமை தந்து நீ வளர்ச்சி கொடு, அகத்திலும் புறத்திலும் மலர்ச்சி கொடு. வளர்ச்சி கொடு, வளர்ச்சி கொடு, கொடு, வளர்ச்சி கொடு.
Now I request our head of the department, Dr. K. Fatima, to welcome the gathering.
Good morning to one and all assembled here. It is a moment of great privilege and honor for me to extend a warm welcome to all of you today. First of all, I thank our principal ma'am for her encouragement and support to conduct this webinar. And I also thank Dr.Deepa Boppana for accepting our invitation to deliver a lecture on intellectual property rights. On behalf of the Department of Biochemistry, I extend a warm welcome to the guest speaker for the national level webinar on intellectual property rights and overview. I would also like to welcome all the participants of this webinar, faculties and research scholars from various colleges who have joined for this session. Department of Biochemistry started with UG course in 1981, then upgraded to research department in 2006, and we have produced around more than 100 MPhil research scholars and 35 PhD research scholars. Today, we are organizing a webinar on intellectual property rights for the benefit of the research scholars. The resource person for this webinar, Dr. Deepa Boppana, founder and director of Intelpet, Chennai, will address us on intellectual property rights today. I feel proud to say that she is our college alumni and she has completed UG chemistry in the year 1997. Dr. Deepa Boppana, a registered Indian patent attorney, holds a doctoral degree in analytical biochemistry and a bachelor degree in law. I thank once again Dr. Deepa Boppana for accepting our invitation to deliver a lecture on IPR. Hope this lecture will enlighten the faculties and researchers today. Thank you very much.
Thank you, ma'am. Now I request our senior faculty member, Dean Research, Dr. K. Vijayalakshmi, to unfold the research activities at our college. Vicky,
And
ma'am?
research scholars. Can you hear me?
Yes, ma'am. Go ahead.
I am audible, yes. Good morning to one and all assembled here. It's a very proud moment to address as an alumni and a staff of the Department of Biochemistry. On behalf of the Department of Biochemistry, I welcome Dr. Deepa and other faculties and young researchers. IQAC, which is known as Internal Quality Assurance Cell, has two important goals. The first one is to improve the academic and administrative performance of the institution. The second important goal is to provide measures for the quality enhancement through best practices. So with this in mind, the Department of Biochemistry has organized this national level webinar for our researchers and young faculty who are actively engaged in research. So my dear researchers, this webinar will enlighten you on patent, trademark and copyright. At Bharati Women's College, we have 6 departments which are actively engaged in research. The 3 arts departments are English, Tamil department and history department. The science departments are biochemistry, botany and geography. So we have more than 50 to 60 research scholars who are actively, both part-time and full-time, who are actively engaged in various research activities. If I am not exaggerating, this webinar will enlighten these research scholars and young faculty who are involved in research, and in future years we may have a few patents, trademarks and copyright for our institution. So with these few words, I call upon all the researchers and young faculty who are involved in research to motivate their students to apply for patent, trademark and copyright. Thank you very much.
Thank you, ma'am. At this juncture, I would be failing in my duty if I don't express a sincere thanks to our Madam Principal, who was always a pillar of support in all our academic activities. Due to administrative reasons, she could not join the meeting, but her wishes always carry us to reach our goals. Now, I call upon our senior faculty member, Dr. M. Premalata, to introduce our speaker of the day, Dr. Deepa Boppana, founder and director. We are proud to mention again, she is the alumni of this college.
Pleasant and warm good morning to everyone. On behalf of Department of Biochemistry, Bharati Women's College, it's my immense pleasure and privilege to introduce today's resource person, Dr. Deepa Boppana, for national level virtual webinar on intellectual property rights and overview. As an alumni, I am very proud to say Dr. Deepa is an alumni of our college. She has completed her undergraduate degree in chemistry in the year 1997 in our college. Her postgraduate degree in chemistry from Ethraj College in the year 2000. She has started her career as a lecturer from Loyola College in the year 2001. and she gained more than 7 years of teaching experience from various colleges. Her keen interest on research was evidenced by her paper publications in both national and international peer-reviewed journals. She is a registered Indian patent attorney and holds a doctoral degree in analytical chemistry from Loyola College and bachelor's in law from Dr. Ambedkar Global Law Institute, Venkateshwara University. Adding feather to the cap, she has obtained Women Scientist Scholarship Award, specializing in intellectual property rights, instituted by Department of Science and Technology, that is DST, Government of India, from 2008 to 2009. She has several years of experience in the field of intellectual property rights as a patent trainee, patent agent, and patent attorney, and drafted more than 500 patents. Presently, she is running an intellectual property firm, Intel Patent Solution in Chennai, and working to file patent for more than 16 institutions, including Madras University. Dr. Deepa has profound potential in diverse technical fields for patents, including physical sciences, life sciences, biotechnology, pharma, medical, and etc. Dr. Deepa offers services to R&D labs, industries, academic institutions, and provides assistance right from drafting the application, filing, and prosecuting till the grant. She also has sound knowledge on patent searching tools like STN, MicroPact, QPact, Skyfinder, USPTO, EPU. Really, it's very, very proud to say the alumni is come as a research person to our college. I am very proud to have you, madam. Thank you very much for the opportunity given to me. Thank you all. Over to Meenakshi.
Thank you, ma'am, for the nice introduction about our guest speaker. Now, I call upon Dr. Deepa Boppana to deliver a lecture on IPR and overview. A gentle reminder to the audience, please mute your audio and video. Enjoy the lecture, and the floor will be open for discussion. Thank you.
Thank you, ma'am. Am I audible?
Yeah, audible.
Thank you, ma'am. Thank you for the nice, very elaborate introduction on me. Yes, I do happy to address my own college. Yes, it's some sort of happy, exciting situation also to me. Yes, I belongs to chemistry department from 94-97 batch. Those days there were no like postgraduate in chemistry, so I shifted to Etraj College, and after that I went to Loyola College for my research. Yes, we will start the topic. The topic goes like this: the intellectual property rights and overview. That's what the given topic, and it is also a tool for a professional enhancement. Yes, before going into intellectual property, I'll just explain. We all know what is a property. Earlier concept, we know there are two types of properties, that is movable property and immovable property, and it is comes under the purview of tangible property. That is, we can see the property, we can touch the property. That is what tangible property. So the two types of properties are movable and immovable. Movable means cars, cattle. These are all movable properties. Immovable are land, trees, buildings. These are all immovable properties. This is the earlier concept of what is a property. Now the present concept is, apart from this movable and immovable property, there is another property, which is intellectual property. That is the property arising out of human intellect. This
மனித அறிவிலிருந்து உதிக்கிற அறிவியல் கண்டுபிடிப்புகள், தயாரிப்புகள், படைப்புகள் இதெல்லாம் பாதுகாக்கிறத அறிவுசார் சொத்துரிமை in literal Tamil. Okay, so this is what intellectual property, the property arising out of human intellect. And it is intangible property, which means you cannot see that property exists, but you cannot see or touch the property. You own a patent. Where is the patent? Can you see that patent? No, it cannot be seen. That is what intangible asset. It is an intangible asset, but still you own the property, so you have certain rights over that property. Okay, so just an introduction of what is an intellectual property. It is a kind of intangible property created with the effort of human mind or intellect. So with the help of human mind, you are creating a property. That is what intellectual property. And if there is a property, there will be some right over that property. Okay, whose these rights will be vested on? It is vested on the creator. The creation of the intellectual property will be vested on the creator. That is the person who has created the property. If it is a scientific invention, he is an author. If it is a inventor. If it is a copyright, the author will be the owner of the property. See, I said it is a property. Like any other property, it can be bought, sold, mortgaged, licensed, exchanged, or gifted to others like any other property. So this is what the intellectual property. See, every property you own, you have certain rights over that property. See, as far as intellectual property, what is your right is exclusive rights, which means nobody else can lawfully use the intellectual property created by them without their permission. This is the right you are getting as far as intellectual property rights are concerned. That is, no one else can use your property without your permission. For example, if you take a cinematography work, only the producer owns the property. So without the permission of the producer, nobody should use the movie. So that is what the right you are getting as far as intellectual property rights is concerned, which prevent others from market, manufacture, and use. Let us see what are the various types of intellectual property. There are two types. It is industrial property and copyrights. Coming to industrial property, these are all three types. Patents, designs, and trademarks will fall under industrial property. And then non-industrial property is copyrights. And apart from that, there are yet another properties also: geographical indication, layout of integrated circuits, etc. There are many number. Today we are focusing only to patents, designs, trademarks, and copyrights. We will see one by one. First, we will elaborately see what is a patent. See, what is a patent? Patent is a right, protection granted by the national government. See, patent is a right which is granted by the national government. Here, central government of India. So, if you want, see, I said patent is a protection. That is a right. If you want the right, in all countries, you have to file in each country individually. If you want to have protection in India, you have to file your application in India. If you want to file protection in US, you need to file a application in US. Likewise, it is in each country, you have to file individually. So what protection you are getting excludes others from making, using, or selling. This is the protection you are getting, and it is for a period of 20 years. And then not all scientific inventions are patentable. Only those inventions which is new, useful, and non-obvious. I will explain this in the forthcoming slides. What is new, useful? So for an invention to become a patentable subject matter, it has these three conditions must be obeyed. That is, your invention should be new, and it has have some use, and also it is non-obvious. And in India, it is enshrined in Patent Act 1970, and it is operative whole of India. It's just an introduction on patents. Why object of patent? Why patent? Of course, to enjoy exclusive right over invention. See, if you are coming out of an invention, you might have spent enormous amount of time, money, energy, everything. So you have to have certain rights over your invention. Of course, to encourage scientific research, new technology, industrial progress, to ensure commercial returns. And this was taken from a famous Supreme Court judgment where the judgment states that the price of grant of monopoly is the disclosure of the invention at the patent office which after the fixed period of monopoly passes into the public domain. This is the ultimate object of the patent law. See, what is patent? Monopoly right. What is patent? It is a monopoly right. That is, you can prevent others from market. See, I have invented a drug, for example, an anti-cancer drug. I can prevent others to market, manufacture, and use. Okay. So since you have invested time, money, everything, government is giving certain right to you for a fixed period. As far as patents is concerned, it is 20 years. After 20 years, what will happen? It should go into the public so that the generic version of the drug will come into picture. So that is what the object, that is, government will give right for a person who is the owner of the invention for a particular, and after that it should be come to public. That is what the ultimate object of the patent law. A crisp definition of what is a patent: it is a right granted for an invention by the government to the inventor or his assignee for a limited period, and it is valid within the country of grant. This is what a crisp definition. See, patent is a right. It is given for an invention, scientific invention. By whom it is granted? By the government. To whom? To the inventor. See, if you are a person is inventing something, he will be the owner, or you are using the infrastructure of Bharati Women's College, college will be the owner of the patent. For a limited period, it is for 20 years. If you file an application in India, you can get protection only in India. I said, what is the exclusive of right? I said already, it excludes others from market, manufacture, and use. That is what you are preventing others from market, manufacture, and use. So I must say the three statutory pillars for an invention to become a patentable subject matter are novelty, inventive step, and industrial applications. These are the three important conditions. We will see one by one. What is novelty? That is, your invention should not be available anywhere in the state of art, global state of art. What is global state of art? Magazines, journals, books, newspapers. These are all state of art. And also, if you are describing your invention in a conference, seminars, or workshops, or you are using the invention before that, will spoils novelty. And then, so this is the reason why your invention should be novel. It should not be available anywhere in the state of art. And novelty is assessed in globalized context. It should be new throughout the world. It may be new to India. It is not like that. If you want to file a patent, it should be novel throughout the world. This is the first condition. Your invention should be new. The second one is inventive step means inventive step. The second condition is inventive step, which means a feature that makes the invention non-obvious to the person skilled in that, which means what Act says is your invention should have technical advantage over the previous invention or economic significance or both. So this is the essential condition for an invention to become inventive, which means it should either have an advantage, technical advantage, or it should be cost effective, that is economic significance, or both. So this is the thing. And then usefulness, of course, there should be some use for your invention. No use, no patent can be granted. So these are the three conditions for you have an invention with you. What are the three conditions? It should be new, it should be inventive, it should have some use. So these are the three conditions. New means nowhere in the global state of art it should be available. Inventive means it should have economic significance or technical advantage. And it should have a use. Even though if your invention is having all the three criteria, novelty, inventive step, and industrial application, okay, if it falls under Section 3 of Indian Patent Act, no patent shall be granted. So, okay, what is Section 3 states that? Section 3 states what are not inventions. Okay, if your invention is frivolous or obviously contrary to the well-established natural laws, that is, you have invented a time machine so that you can go to the past or the future, which is against natural law. So such kind of patents shall not be granted. And then if your invention is contrary to public order or morality or prejudice to human, animal, or plant life or health or environment, that is, for example, you have devised a device, you have fabricated a device for committing theft, or you are formulating a biological warfare weapon, which is against public order or morality, these are all non-patentable. And then discoveries are non-patentable, only inventions are patentable, which means What is the difference between discovery and invention? Newton's law of gravity is a discovery. Alexander Graham Bell's telephone is an invention. That is, some human intervention should be there to arrive at a product. So discoveries are not patentable, only inventions are patentable. And then new use of a known compound is not patentable. This is section 3D, important section, where aspirin, we all know it is analgesic, pain relief. Later, it was found that it is having excellent cardiovascular property. That is new use of the known. Aspirin is known, the use is new. So there are no use patents in India, only product and process patents are granted. And then mere admixtures, you are mixing A, B and C, and it is coming only with additive effect, no patent. If there exists some synergism, then patent shall be granted. And then mere arrangement and rearrangement of nodal. See, this is a very good invention, umbrella cum torch. During rainy season and night time, it is be very useful. But patent office rejected this patent, stating that it is just umbrella is already known, torch is already known, just fixing, arranging and rearranging of known devices is non-patentable. And then method of agriculture and horticulture, method of treatment. Okay, if for example, if a particular surgeon will be get a patent right over treating a tumor cells, removal of tumor cells by surgery, what will happen? Only that particular doctor has to treat the patient. Whatever amount he is fixing for the surgery, we have to pay, because he has got the monopoly right. What right is getting? He will prevent others to use the invention. So as far as India is concerned, method of treatment is non-patentable. Okay, and then plants, animals, including seed varieties, species, biological process, these are all non-patentable. Mathematical or business methods, computer programs, literary, dramatic, musical, artistic work, and mere scheme, rule, method of playing games, these are all comes under non-patentable subject matter, which is not patent. Presentation of information, topography of integrated circuits, IC, and then traditional knowledge. So no patents for neem, turmeric, etc., basmati rice, etc. So this all about section 3. Okay, section 3 states that what are not inventions, and section 4 also states what are not inventions. Inventions, no patent shall be granted of an invention in respect of an invention relating to atomic energy falling within subsection 1 of section 20 of an Atomic Energy Act. That is, your invention is involving your radioactive substance such as uranium, thorium and plutonium or gamma radiation. And if it is harmful to the society or if it is against our defense purpose, such kind of inventions are non-patentable. That's all. Okay, now you have an idea what are the patentable subject matter. That is, you have a scientific invention with you. You have to first check the 3 criteria, whether it is new, inventive, and it is having some use. Even though you are all the 3 conditions are satisfied, you have to cross check whether your invention falls under section 3 and section 4 of Indian Patent Act. Okay, you have found that, okay, my invention is obeying all the 3 criteria and it is not fall under section 3 and section 4. Next, we have to file our application in the Indian Patent Office. When to file? Earliest possible date. So you have got an invention with you. Immediately, we need to go and submit our application in the Indian Patent Office. Why? Because delay in filing, somebody working in the same field may file a patent, so he will get the right. Okay, or you yourself will publish your invention or talk it in the conference, something like that. So the genuine answer for this question, when to file, earliest possible date. And this is a very important question. Can a published or disclosed invention be patented? The answer is no. So you have got an invention and you found that it is worth it for a patent filing. Don't publish your invention. First, go and deposit your application in the Indian Patent Office and then come for publication. For the same invention, you can file both patent and publication journals. Okay, so always keep it in mind. If you have got a very good invention, file the patent first and then go for publication. If you publish your invention, your patent right will be lost. And next thing is the 3 important questions: who can file a patent application, where to file, and how to file. Who can file? Okay, who can file? The inventor has the right to file, or you are working on behalf of the institution has a right to file. In the beginning, I have said it is a property, like any other property. So the legal representative of a deceased person has a right to file the patent application. So these are the three persons who can file a patent, either the inventor or the institution, or the, in absence of both the two, the legal representative has filed. Where to file in India? There are 4 places: Chennai, Mumbai, Delhi, Kolkata. We falls under this Chennai South Zone. Kerala, Tamil Nadu, Karnataka, Andhra Pradesh, Telangana, Puducherry, we all fall under Chennai Patent Office, and it is in Guindy. How to file? It can be filed through online or post, or you can directly go and submit your application in Indian Patent Office. This is the, and let us see the procedure for filing. First, we have to file our application in the Indian Patent Office. After 18 months, it will get published in the Patent Office Journal. Okay, so this is the first stage, that is publication of our patent. Filing and then publication, or you can opt for express route, express publication, where that publication will happen within 2 weeks. Else, you have to wait for 18 months for the thing to get published. And then after publication, that we may receive any opposition from the things. If somebody comes, somebody finds that, like he has copied his invention, he can file opposition against you. Or if somebody is interested, okay, to purchase your product, he can come for licensing the product. So 2 things may happen: opposition or representation. And then your invention is taken up for examination. They will examine and they will send you an examination report, and we have to file reply to that examination report. And if the reply is satisfied, they will grant the patent. Okay, this is what the procedure. That first one is filing, and then publication, and then examination, and then grant, and then decision of controller will be the final. So this is the procedure for patent filing: filing, publication, examination, grant. Okay, so far we have, I think I made you clear what is a patent, what are the patentable subject matters, how to file, where to file, everything till on the procedure for patent file. Next, let us see the copyrightable subject matter in India. What Oxford Dictionary states is, it is an exclusive right given by a law for certain term of years to an author, composer to print, publish, or sell copies of original work. So this is the right. See, you have penned a book, which means you will be the author of the book. So you have certain rights. What rights you are having here? See, it is an exclusive right. What right? Right to copy or reproduce. That is the right to publish your book. And then another right is to do authorize, that is you can give license to the publisher to publish your book, so that you can get royalty over that. And of course, it is a product of human skills and mental capacity. And it is, and also this is also the same thing. It is the right given by the law. Here also, Indian government is giving the right to whom? To the creator. If it is a literary, dramatic, musical, and artistic work, to the creator. If it is cinematographic, film, and sound recording, it is the producer who is the owner of the copyright. So I must say, copyright is a bundle of rights. So what right you are getting? You have the right to reproduce. You have the right to communicate. You have the right to adapt, and you have right to translation. You have penned only Tamil version of a book. You get all the languages throughout the world. In French version also, nobody should translate your work. So that is the right you are getting. That is what? Bundle of rights. People used to say copyright is a bundle of rights. What are the subject matter of copyright? So these are the various subject matters. That is a cinematography work, artistic work, dramatic, musical, literary, sound recording, computer programs. So these are the various subject matters in which one can opt for copyright protection. So who is the owner? That is the author of the work is. For literary, for if you are writing a literature or a drama sort of thing, author will be the owner. The person who is writing. If it is an artistic work, the artist. If it's a musical work, it is the composer of the music will be the owner. If it is a photographic work, it is the photographer. And for cinematographic work, it is the producer is the owner of the copyright. So, okay. And then for computer work, the programmer. And coming to the artist, we will see what are all comes under artistic work. Artistic work is any paintings, sculptures, drawings, engravings, architecture, craftsmanship. These are all the various subject matter of artistic work. Coming to cinematography work, we all know sound recording accompanied with visual images. That is, video film with sound is the cinematographic work. Literature, all are literary works. Everything falls under literary works, which includes computer programs, tables, compilations, including computer database. So these are the various subject matters of literary work. That is, books, e-books, new edition of books, novels, stories, plays, poems, song lyrics, concept notes, everything, all literature work will fall under. The only condition is it should be original. It should not be generic. That is one the condition. Remaining everything is copyrightable. So what are not copyrightable is single word. Just a single word or a title or 2 or 3 sentences, slogans, certificates, blank form, flashcard. These are all non-copyrightable subject matter under literary work. Okay, what is musical work? That is, those who are involved in music will be knowing that sheet music, you can see in the graphical notations that bruise, semi-bruise, such kind of things falls under musical work. What is sound recording is you are recording the music in a medium such as CDs or pen drives. That is sound recording. So now you can able to discriminate between the musical work and sound recording. Musical work is a sheet music which is written in a paper. Sound recording which is recorded in a medium. That medium can be a CD or a pen drive, which involves either music or with lyrics or without lyrics. And what is the right of the copyright holder? We have seen earlier, a right to reproduce, communicate to public, issue copies. You have the right to assign your thing, assign your copyright, and of course you have to right to grant the license. Okay. So it is, let's see, look at the time. As far as patent is concerned, it is 20 years, whereas as far as copyright is concerned, 60 years from the date of the date. That is, if an author penned a book, okay, it is the how many years he will get the right, he will get the royalty from the publisher is his lifetime, and from the date of death after 60 years, up to 60 years after the death, he is getting the right. After the death also, his legal heirs will get the royalty of his work. This is the term period for copyright. And the registration flow will be like that. It is very simple. Within 3 months, we can get the grant certificate as far as copyrights is concerned. First, we have to submit our work with the copyright registry. They will publish in their website, and then if no objection is received, no discrepancy, they will grant. If there is some discrepancy, we have to reply for that discrepancy. If they are satisfied, they will grant the patent. Else, they will call for hearing, and then the grant or rejection will take place. So this is the flow chart. First, filing, publishing. I mean, publishing in the sense they will keep it. It will be available in the website, and then if there is no discrepancy, they will grant. If there is discrepancy, we have to file the reply. Satisfied reply, they will grant. Else, hearing, grant or rejection will take place. So this will be the flow chart for copyright registration. So what is the advantage of this copyright registration is because you have right after 60, I mean, death, at 60 years after death. So if you own a copyright, it will be useful for you. And also, once you file a copyright application in India, through all the designated countries, you get the copyright. Okay, see, as far as patent is concerned, what I said, you have to file in each country individually. Whereas in copyright registration, all the signatory countries who are the signatories of Berne Convention, if you file in India, if you get a copyright in India, you can get royalty from US also. You can get royalty from UK also, because all are signatory countries under Berne Convention. So throughout the world, you will get the right. That's all about copyrights. Coming to trademarks, it is something that distinguishes your product from others within the market. That is, these are the various well-known trademarks like Cipla, Coca-Cola, Procter & Gamble, Novartis, Johnson & Johnson. These are all various trademarks. So what can trademark? It can be a word or a name, slogan, logo, design. See, Kit Kat, have a break, have a Kit Kat. That is a slogan. This can be protected under trademark. a color scheme, a smell, a sound. These are all various things. What is the object is, of course, to prevent confusion among the consumers, to control the repetition and to protect the goodwill of your brand name. So this is the object of the trademark. So what essentials is, it should be distinct in respect of goods. That is, for example, Apple for computers. Apple is a fruit. Computer is an electronic device, right? So it should be distinct so that you will get the grant. Easy to pronounce, remember, spell and write. It should not be confusing. Preferably an invented word. This is Kodak for cameras. There is no meaning for the word Kodak. It is just a coined name. Such kind of names you will get protection very easily. And it should not belong to the mark prohibited by law, that is the emblems of India. It should not contain obscene matter, and it should not hurt religious or sacred feelings of any citizen. That's all about trademark. That is, if you want to give a brand name to any article relating to commerce, that is goods and services, there comes the trademark. Coming to industrial design, design is a beautifying an industrial product to attract the customers. That is what. That is the shape of the product, which will gives an aesthetic look, forms the design. See, if a person is selling, if two companies are selling the same product with equal functionality, means how can then appeal the consumers? By the design, by the external appearance of the design. Okay, and this design can ranges from shape of product to the packaging. Packaging design also you can get protection. And here it is for 10 years and it is valid up to 5 years. See, patent it is for 20 years. Copyrights it is for lifetime plus 60 years. Trademark, there is no thing. If we continue to pay the renewal fees, you will get the mark. And for design, it is a maximum of 15 years. Okay, that's all about copyrights, patents, trademarks, and designs. We will see some interesting case laws in here. First one is Basmati rice case. Basmati rice case. See here, a company called American Company Rice Tech, they have filed a patent for Basmati rice. So what they have claimed is, my rice is having long grain, length of the grain is very long, and then the aroma, and then rich starch index. These are the three claims they have mentioned. And then see what will happen if American company has got the patent right for Basmati. See here, major producers of Basmati rice throughout the world is India and Pakistan. That is the northern part of India and Pakistan. So if they get patent rights in their country, what will happen? They cannot export their goods to them, to those markets. So it will be a big loss for India and Pakistan. And of course, they have filed a case against the American company Rice Tech, and India government has won the case. Now we are free to export our Basmati rice to Europe and Western countries. So this is the fact of the case. They have filed a case, filed a patent in the US for Basmati rice, and later it was got cancelled. Of course, they are still retaining these three conditions, that is the length of the grain, the aroma, and the starch index, but that is also debatable. Coming to turmeric case, that is the patent case for turmeric. So the fact of the case is, the University of Mississippi, they have filed a patent for neem. See, they have very meticulously drafted like a method of treating surgical wound by turmeric. See, and then I must say CSIR has done a commendable job, and they have fight till the end, and they have cancelled this patent case. So there is no patent for turmeric wound healing. So that patent got revoked in US. So in April 1998, CSIR won the case and the patent has been cancelled. So turmeric is the traditional knowledge, right? Turmeric is the traditional knowledge. So they have filed it for surgical wounds, and we see CSIR has found one evidence. See, US court has asked, where is the evidence that turmeric is used for surgical wounds? CSIR, in one of the Persian language journal, it was found that during delivery, after cutting the umbilical cord, they have sprinkled turmeric over that umbilical cord. So that document has shown as an evidence that turmeric is already known for curing surgical wound, and then the patent has got cancelled. That is what the neem turmeric patent case, neem patent here. And the fact of the case is the American timber importer Robert Lawson, what he did, he has imported the neem seeds from India, and he has grown neem trees in US, and also he has found an emulsion for neem. With the neem, he has get an emulsion, and it is proved to be an antifungal agent for plants. So this is the claim here, and he has filed a patent in US. So very pathetic part is he has filed a case against Indian companies not to use neem as an antifungal agent. And here, see, neem, we used to say it is a village pharmacy. All the parts of the neem, right, starting from root, stem, bark, leaf, fruit, seed, flowers, everything is having excellent medicinal properties. So here we have filed a case against them, and we, of course, we won the case. And this is the first case for biopiracy of theft of our knowledge, traditional knowledge from US and European patents. So, and later, see, we won the case, but hereafter the European Patent Office and US Patent Office, they are very particular that the invention should satisfy the three conditions: novelty, non-obviousness, and utility. Okay. And then compulsory license. So far I have said that patent owner has the right. What is the right he is getting? He can prevent others. He can prevent others from market manufacturing use. But there are certain conditions where the government of India can grab the right from the patent owner, and this is called compulsory license. For example, see, and so far in India, only one patent has been granted. Compulsory license has been issued. Here, the fact of the case is Bayer is the owner of a patent which is sorafenib tosylate, which is sold under the brand name Nexavar, and it is for renal cell carcinoma and hepatocellular carcinoma. See here, look at this. Only 2% of cancer patients has right to able to access the drug, and look at the amount, 2.8 lakhs for 1 month. And it is not manufactured in India. They are importing it from outside India. So these are the three conditions. If these three conditions are satisfied, that is, if it is not available to all the people, a patented drug, if it is not available to all the people, and it is exorbitantly higher price, which we cannot afford to buy the thing, and if it is not worked in India, the government can grab the patent right from the patent holder and give it to somebody else to manufacture the generic version of the drug. Okay, so as far as in this Bayer case, all the three conditions are satisfied. See, even though people wants to spend 2.8 lakhs per month, only 2% of the kidney and liver cancer patients are able to access because the drug is not available, even though they are willing to spend too much. So what happened? This is the first case where compulsory license has been granted from Bayer to Natco. The conditions of compulsory license is he has to pay only 6% royalty to the Bayer, that is the owner. And he look at the price, it should be rupees 8,800 only. Initially it is 2.8 lakhs, whereas here it is 8,800 rupees only for 120 tablets. And also Natco should give 600 needy patients free tablets. This is the condition of compulsory license. And here this is a famous case, Novartis versus Union of India. See, this pharmaceutical company, US-based company, he challenged our Constitution of India, stating that there is no equality before law. The fact of the case is, Novartis, he has filed a patent for a compound, Glivenic, and he has got patent rights of 35 countries, and it is for leukemia. Okay, here the compound is imatinib mesylate. It is in beta-crystal form. Other forms are already known. It is a new form of a known compound, so which falls under section 3D of Indian Patent Act. So patent office refused to grant the patent, but it has been granted in 35 countries, but patent office refused to the grant of the patent. So what happened? These filed against, the case went up to Supreme Court that he wants the patent right for that drug. But Indian Patent Office was very particular. They don't want, because Sections 3D states that new form of a known compound. This compound is already known. Imatinib mesylate is already known, but it is a new crystalline form. That's it. So they are very particular about the thing, and they never granted the patent. And finally, Novartis decided to stop any further investment in R&D. So they left the country. So far we have seen various patent cases. Coming to copyright cases, Kajar Agarwal versus VVD. We all know VVD advertisement. Kajar Agarwal is the model of that. So she filed a case against VVD that for every year she needs the royalty, because the advertisement is keep on telecasting for more than 1 year, but she was paid very minimal amount. But as far as cinematography work is concerned, the producer will be the owner of the copyright, and he has right to exploit his cinematographic film. So here in this case, Kajar Agarwal lost the case. Coming to the trademarks, this is the symbol for Mercedes-Benz, and VIP undergarment. See, they have come out with the same name, Benz. Look at the logo, a man holding hands raised and two legs apart, which is similar to that of the Benz symbol. The Benz, see, it is not only copying the thing, they are insulting their brand name. Such a prestigious brand with an undergarment. So they have filed a case against VIP. So this Benz VIP undergarments is not now available in the market. This Benz car, Mercedes-Benz won the case. Coming to the design patent, see here, this is Bablu or Bound 2, the movie where Rani Mukherjee, that is blue color pancho with heavily embroidered trouser. This was the dress designed by the designer Sunit Verma, and it was incidentally used. The costumer of the movie has purchased this dress from one shop, and he has been used. And in all the CDs, everything, this picture was posted, and there was very big sale for this. So the designer said, "This is my property. This was designed by me. I want to get royalty because using this dress only they are minting money." But here, the court gave judgment in favor of the producer, the cinematographer, was because incidental use of the designed product is not an amount to copyright. I mean, infringement, that is copy. And you can see in wheat, the S-shaped spatula, they have filed a design application for this. But Anifrance is already having this product, design writing. Here in this case, Anifrance won the case. So, if somebody copying your invention, your intellectual property, that is either patent, trademark, copyright, or design, what is the remedies means? You can opt for civil remedy, criminal or administrative. What is civil means? You can opt for injunction, damages, or accounts on profit. If it is criminal, of course, imprisonment and fine. If you own it can be commercialized by the owner itself, or you can sell your product, or you can give license. Selling means assignment means total selling. Licensing, partnership means you are giving rent sort of thing. You will be the owner, and he can enjoy your intellectual property rights. Thank you.
Thank you, ma'am, for your inspiring talk in a simple language. Your lecture was elaborate, informative, highlighting the diverse aspects of patent, copyright, trademark, and design. Your explanation on how to start and go about on all these aspects was clear, and I believe it would have satisfied the expectations of our audience. Now the floor is open for discussion. You can post the questions in the chat box, else unmute yourself one by one and you can clarify your doubts.
Ma'am, good afternoon.
Good afternoon, ma'am.
Ma'am, I'm having some doubts. Your explanation is very good. If I own a patent for a particular product or anything, if I want to partner with others, can I do that? I mean, my sister or any friend.
Yes, see, here it is a property. If you want to have any sharing of your property, you can do that.
Okay, ma'am. Ma'am, I'm having second doubt too. If nowadays we are hearing some news that if a farmer is landing doing their work in there, and other country is taking consumption and patent right. I can mention tobacco case, which is US dead patent from our India for 17 years. I if a case, who's owning the ownership? That is, who's fixing the rate?
Patent owner only fix the rate. The applicant is the owner and he only fixes the rate of the product. And if he gets the patent right, people have to purchase that product only from him. If it is exorbitant, as we seen in this Bayer and Natco case, the compulsory license will be given by the government of India. Always here, the owner of the intellectual property has the right to exploit. Because he has
Ma'am,
invested.
if suppose the case will turn like this, how means if I own a property and I'm judging a rate for a particular product, and my partner, someone, he's also doing some work. If we get clashes between us, if he's subjected this case to the court, then what? How will be the judgment will be there?
See, it is up to the court to decide. You have to give your things to the court, how you have involved in this research, what is your contribution towards the research, and the person also, they have to give their own advantages of the thing. Everything will be decided by it. Will be go like a normal civil case in the court of law. It is just a dispute between a property dispute, likewise only. It will be the dispute, and you need to give evidence for your contribution. If your contribution is more and her contribution is less, such kind of things, the legal battle will be taking place, and the judge will decide the case based on the evidences submitted by both the applicants.
Yes, ma'am. Ma'am, you told about the copyright issues. Nowadays, YouTube is very popular. And most of them are criticizing or using the other products like that, commercial products which are sold in our market. There they are raising a copyright issue. What is the meaning of that?
So what copyright issue they are raising? See,
I heard some of the YouTube channels were saying if a product is publication more than 5 seconds, there will be raising a copyright issue. What kind of copyright issue they are raising?
no. The thing is, as far as YouTube's copyrights are concerned, you are not supposed to use other copyrighted cinematography works or copyrighted products in your channel. Okay, if that is the case, the owner of that copyright will file a case against you. Okay, if you are using other copyrighted stuff into your YouTube channel, you have to give certain credits to that. That is, you have to mention that it was taken from that part of that piece of copyrighted work, and I don't have that. Such kind of disclaimers you have to mention in your YouTube channel. Then you won't get any copyright infringement suits against you. If you recognize the owner of the copyright and also disclaiming that I doesn't own any copyright for this piece of work.
Thank you so much, ma'am. Your information were very good and informative too.
Thank you.
Any other questions from the audience? I think there's another question from the audience. Thank you, ma'am, for your positive response for the questions raised by the audience so far. Now I request our faculty member, Dr. Vichitra, to deliver the vote of thanks.
A warm and graceful good afternoon to everyone present here. It's my privilege to propose vote of thanks on this event. On behalf of Biochemistry Department and IQAC of Bharati Women's College and the entire fraternity of this institution, I extend my sincere thanks to Dr. Deepa Boppana, founder and director Intelpet Chennai, for elaborating the tools for professional enhancement and have enlightened our minds on patenting and the what to patent, where to patent, and how to file a patent, and the copyrights of India, etc. Thank you. Thank you, ma'am. And I thank our principal, madam, Dr. D. Gladys, for being the catalyst that stimulated biochemistry department to do our best and the standing pillars of strength and making this event a resounding success. I would also like to thank Mrs. Shenbaga Priya, research scholar of geography department, who worked behind the scene in live streaming of this virtual webinar. With a deep sense of appreciation, I thank our staff members for the supervision, inspiring notes at every point of the time in this pandemic situation. I want to extend my generous thanks to the entire faculties and researchers who has participated in this webinar from long distance through online and for the support and cooperation. On behalf of Biochemistry Department and the staff members of the entire college and IQAC, and once again thank to everyone who has participated in this webinar, virtual webinar. Last but not least, I thank Almighty for making this today's event a grand success. Once again, thank you one and all.
Thank you, ma'am. Thank you for the opportunity.
Thank you, ma'am. Participants, the feedback link is shared in the chat box. Please fill the form and give your valuable feedback.
Meenakshi,
Yes, ma'am. சொல்லுங்க.
after filling the forms, you can just tell them, no, they will be getting their
Certificates ka?
certificates.
Okay. Participants, you can fill your feedback form. Once we get our forms, your certificates will be dispatched to you.